I don't.
Okay, we are live. All right, here we go. And I swore in your officer. All right, your witness.
Thank you.
Sir, what is your name at the podium there?
Martavius Redding.
Okay, thank you, sir.
Deputy Hunter, would you please tell us your name and how you're employed?
Deputy Jamal Hunter with the Clayton County Sheriff's Office.
How long have you worked with the Clayton County Sheriff's Office?
Approximately 8 months.
Were you working with the Clayton County Sheriff's Office on April 30th of 2020 around 3:15 a.m.?
I was.
On that particular day and time, were you assigned to the Morning Watch Tactical Patrol Unit?
I was.
Were you part of, I guess, the unit that conducted a road safety check at Old Connolly Road and Connolly Way?
I was.
What is the purpose of the road safety checks?
Purpose of the road safety check is checking for licensed driver and vehicle malfunction and making sure all standard equipment is functioning.
Do you recall a silver Nissan Altima coming through the checkpoint?
I do.
And at that time, do you recall coming into contact with Martavius Redding?
I do.
How many people were in the vehicle?
2.
Where was Mr. Redding?
The passenger seat.
Do you recall who was driving the vehicle?
It was a female. I'm not. It was his girlfriend. I'm not sure what her name is. I don't have my report in front of me at the moment.
Okay. When the car pulled up to the checkpoint, what happened?
The odor of marijuana was observed coming out of the vehicle by the sergeant that was on the checkpoint. He informed me. We asked all occupants of the vehicle to step out of the vehicle. We began a probable cause search of the vehicle. Marijuana was located in the center console. Um, while searching the vehicle, I came upon a red backpack located on the back passenger seat. I asked both occupants whose backpack was it. Mr. Redding took possession of the backpack. Um, I asked did he mind if I looked in the backpack. He stated no. Then I asked was there anything illegal inside of the backpack or anything that will hurt me inside of the backpack. He said he was not sure. I asked him what did he mean by that he was not sure. Then he changed his answer to no, it should not be. But when I searched the backpack, I located a firearm that was located in the inside a compartment that was inside of the large compartment of the book bag. So it was a compartment inside of a compartment of the backpack. And once I observed that firearm, we detained both suspects in handcuffs. We ran the firearm. It came back stolen out of, I believe, Coweta County. It was confirmed stolen out of Coweta County by our dispatch. I read both subjects at Miranda. They both denied. They both refused to speak to me without a lawyer present. So they both were subsequently taken to the jail and both charged with the marijuana and the possession of the firearm.
Deputy Hunter, was the criminal history of Mr. Redding also checked?
It was. It showed that he was a convicted felon for several convictions out of Fulton and DeKalb.
Okay. And when you signed off on the warrantless arrest probable cause affidavit, I know you said he had several convictions, but do you recall which one you specifically you listed on the affidavit?
Yes, ma'am. I believe I cited robbery. There was a conviction of a robbery charge out of either DeKalb or Fulton. I'm not sure of the municipality.
Okay.
Um,
And let's go back to the gun. Do you recall when the date the gun was confirmed stolen out of Coweta County, or when it was stolen out of Coweta County?
Unfortunately, I don't have my report in front of me. I do not recall that date.
Okay, but you were able to confirm that it was stolen out of Coweta County?
Yes, dispatch was able to get in touch with Coweta and they confirmed that that firearm was stolen.
Okay. Did you locate anything else in that backpack that belonged to Mr. Redding?
No, ma'am. Nothing else was located in the backpack.
Okay. But Mr. Redding did take ownership of that backpack?
Prior to the search, yes, ma'am.
Okay. The marijuana that was located in the car, where exactly was it found?
In the center console.
Was it in the, I guess like the cup holder area, or was it in a
Yes,
compartment?
Yes, ma'am. It was the center console cup holder.
Was it loose marijuana? Was it packaged in any way?
It was packaged in a I guess they call it high grade marijuana package. So it was packaged in like a Ziploc bag almost.
Do you recall the weight of this marijuana?
I don't.
Okay. It was less than an ounce?
Yes, ma'am.
And Your Honor, if I could, I guess, have my investigator, I certainly would, because I asked Deputy Hunter about the date of the gun where it was stolen out of Coweta County. And I certainly would like for him to be able to testify to that, but I would need to send him his report. Unless Mr. Rose has no objection to me, basically, I mean, saying.
No,
what
no. I think
Okay.
we've done this before consistently since we're stuck modifying the way that we have these hearings. So
Okay, I just want to make sure.
we'll take a couple of minutes just to let your investigator get that documentation too.
Yes, give me 1 second. Thank you.
Not a problem.
And Judge, I believe Deputy Hunter is ready to proceed when your honor is ready.
All right. So Deputy Hunter, we're back on the record. You were able to get a copy of your report?
Yes, Your Honor, I was.
All right.
I apologize, I was muted. Deputy Hunter, before we took a break, I was asking whether or not you recall the date that the weapon was returned stolen out of Coweta County. Do you have, has your memory been refreshed at this point?
Yes, it has. It was 8/20 of 19 that it was reported stolen out of Coweta County.
Did all of this take place in Clayton County?
It did.
I believe that's all I have. Thank you.
All right, Attorney Rhodes?
Yes, Your Honor. Hi, Deputy Hunter. So the vehicle was stopped during a roadside safety check, is that correct?
That's correct.
Was anything observed to be wrong with the vehicle itself?
No.
Okay, so were you just stopping every vehicle that was passing through this check?
Yes. Every vehicle was stopped and inspected, and the license was inspected on from each driver of the vehicle.
Okay. And again, the driver was not Mr. Redding.
No, it was not.
Okay. Now you mentioned that there was an odor of marijuana coming from the vehicle. You personally observed that odor of marijuana?
I was informed by another deputy that was on the passenger side speaking to Mr. Redding.
Okay. So was it that other police officer that asked both occupants of the vehicle to leave the car?
I know. Once he informed me that he smelled the odor of marijuana, he asked Mr. Redding to step out, and I asked the driver to step out.
Okay. Do you have the name of the other officer that spoke to Mr. Redding first?
Yes, Sergeant Kyle Bradford.
Bradford. Okay. So when Mr. Bradford asked Mr. Redding to step out of the vehicle, really, I want to ask, at what point did Mr. Redding reach for the bag in the back seat or mention that it was his?
He did not reach for the bag in the back seat. Once I asked both occupants to step out of the vehicle, they were asked to step to the rear of the vehicle while I conducted a probable or cause search of the vehicle. Um, it's my practice once I come upon any type of backpack or purse, I obtain ownership before I search that backpack, so that property. So I removed the backpack from the back seat and I asked both occupants whose backpack was it, and he took possession of the backpack at that point.
Okay, so he had verbally said to you that that backpack was his.
Yes.
Okay. I want to back up just a little bit. The marijuana that was supposedly found in the center console, was that marijuana found or noticed before you had asked about the backpack?
Yes, it was located prior to the backpack being removed from the vehicle.
Okay. So upon finding the marijuana in the center console, did you have a reason then to search further inside the bag?
I don't understand the question.
You smelled marijuana coming from the vehicle. You found marijuana in the center console, and then you proceeded to search even more so inside this bag. And I'm just asking why you decided to make that decision.
I just continue with my search. You don't stop searching once you locate the marijuana. You continue until you search the full vehicle, and that's what I did.
Okay. All right. So after Mr. Redding had taken ownership of the bag, was he ever advised of his Miranda rights?
Yes.
Okay. Was this before he was asked if there was anything illegal that was in the bag?
Once I grabbed the bag out of the rear of the back seat, I asked whose bag it was. He took ownership of that bag. The firearm was located inside of the bag. He was then detained. He was advised Miranda. Then he advised he did not want to speak to us. He was placed in the rear of a patrol vehicle, and then the firearm was ran over the radio and returned back stolen for GCIC.
Okay. And did Mr. Redding make any statements at all regarding the firearm?
Not to me.
Okay. Did the driver of the vehicle make any statements about the bag or its contents?
No, she was also detained and Mirandized, and she also refused to make any statements without an attorney present.
I understand. And was she ever charged with the contents of that bag, the firearm?
She was also charged with the contents of that bag and the possession of the marijuana.
Okay. And was this encounter recorded on video or audio?
No, it was not.
Okay. And I see. Was the marijuana ever submitted to evidence?
It was.
Okay. And you said that the marijuana was in the center console, is that correct, of the car?
Center console cup area.
Cup holder. And would you say that the driver of the vehicle also would have had equal access to that cup holder?
That's fair to say, yes.
Okay. Thank you. Those are all my questions.
Redirect.
No additional questions, Your Honor.
Do you have any other witnesses?
No, the state rests.
All right, argument?
State waives opening.
Yeah, Sean, I'd like to argue. First, with the marijuana possession. Again, as you've heard, this is not Mr. Redding's car. He was not the driver. The driver was also charged with the misdemeanor marijuana possession. We would argue that, because it is the driver's vehicle, the driver does have primary responsibility for the contents of that vehicle. And again, because it was clearly within the driver's reach, next to the driver in the center cup holder, we would argue that the driver, who has also been charged, is, if anything, more likely to be responsible for this particular charge, and that we ask this charge be dismissed against my client, Mr. Redding. Now, for the theft by receiving charge, there was no testimony that Mr. Redding knew or should have known that that firearm that was found in the bag was stolen. There were no statements made to indicate that Mr. Redding knew anything about where the gun came from. And of course, if it were illegally obtained, if it were stolen. So we of course asked that charge be dismissed. We really don't even believe that the state can, establish the burden of proof necessary to show that Mr. Redding ever knew or could have known that that firearm was stolen. No statements were ever made on that. And for that reason, yeah, we asked for that theft by receiving charge should be dismissed. The marijuana charge should be dismissed because of the driver of the vehicle. And we submit on the testimony for possession of a firearm by a felon. Thank you.
Attorney Freeman, you don't need to argue on the theft by receiving stolen property. Recent unexplained possession. This is not recent. It was August of 2019. There's no way to argue or to prove to me that Mr. Redding knew or should have known that that firearm was stolen. So I'm not gonna, you don't have to argue about the theft. Okay. I think the only thing that you need to talk about is the possession of marijuana, because it was submitted on the felon in possession of a firearm.
Right, and Your Honor, I certainly concur with what Mr. Rhodes said about the marijuana.
All right, so that's gone as well?
That's correct.
Okay, so you're not going to do the equal access argument?
Well, Your Honor, it's the misdemeanor amount of marijuana, and given that it was the co-defendant's car, and certainly Mr. Redding certainly would have had access to that.
Okay.
But I would like to put on the record, I know Your Honor's already made her ruling regarding theft by receiving, but I would like to say that given that Mr. Redding is a convicted felon, that circumstantial evidence certainly he knows as a convicted felon, he is not able to purchase a firearm legally. And so certainly given that, that under circumstantial evidence, we would certainly say that he knew or should have known that weapon was stolen. Because as a result of his record, he would not have been able to purchase that handgun legally.
But still on the record, Your Honor, that handgun could have belonged to the driver. So, I mean, he would not have had a reason to know that that firearm was stolen. It could have been a legal firearm that was owned by the driver of the vehicle. for example.
I'm gonna stand on the dismissal of the possession of stolen property, but we do have felon in possession of a firearm. I do see that you submitted on that charge as well. Attorney Wilson, I would have found probable cause on that one since he's alleged to have claimed ownership of that. But that leaves the other two charges that are dismissed. Can you check on something for me, Attorney Freeman?
Yes, ma'am.
Driver, is the driver in jail? What's happening with the driver?
I'll double check her now. Let me see.
All right, thank you.
She is out on bond on the theft by receiving as well as the possession of marijuana less than an ounce.
So she's charged with theft by receiving that same gun?
She is, and I can tell you what her bond. So she was given an $8,000 bond on the theft by receiving and a $1,500 on the possession of marijuana less than an ounce.
All right, we need to follow up on her, please.
And I'm not sure who's going to represent her because the public defender's office is listed.
Okay. All right. Thank you, Mr. Redding. Do you have any idea whose hearing you want to do next?
Bagley, I believe the officers are, and we have Detective Childs as well as Deputy Arnold.
Okay.
And Your Honor, can Deputy Hunter be excused?
Yes.
Thank you, Your Honor. Have a
Thank
good
you.
morning.
You as well. Take care, Deputy Hunter.
Goodbye.
I'm sending you over that my decision and Redding. Okay.
Thank you, Your Honor.
Yes, ma'am. All right, let me see. All right,
And let's see, I know Detective Childs is, are you able to do your video, Childs?
Yeah, I'm here, I think.
Okay, we can hear you, but we can't see you.
What do I need to do?
There should be a picture of like a camcorder at the bottom of your screen that'll say start video. Are you on a computer or your phone?
I'm on my phone. I couldn't get it to pull up on my computer.
Okay, you should have an icon. It's either at the top or the bottom of your phone, and it looks like a camcorder.
Uh-oh. Yeah, I think
Wait, you had it for a minute. Here you go.
there I am.
There you are.
okay.
I didn't even email them on the court. Or text.
Now, who are you starting? Who's presenting first?
Childs, he has the warrant for the aggravated assault, and then we have Deputy Arnold, who has the drug offenses.
Okay, so what is your name?
The jail is muted.
Okay. Can someone unmute the microphone at the jail over at the,
Yes, Your Honor, sorry about that.
okay, great. Your name, your last name is?
Bagley.
Okay, very good. Let me swear you in, Arnold. Childs. Where's Childs? There you go. The information you give, any testimony you provide in the matter of the state versus Jermaine Bagley is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, very good.
Detective, would you please tell us your name and how you're employed?
Daryl Childs, Clayton County Police Department,
How long have you worked with the Clayton County Police Department?
24 years.
And Detective, were you working with the Clayton County Police Department on April 17th of 2020?
I was.
On that particular day around 6:45, let's see, did you respond to, I guess this is 8423 Avalon Drive in Riverdale?
Yes, ma'am.
Is that Clayton County?
It is.
When you arrived there, who did you meet with?
Denisha Jackson.
What did Ms. Jackson tell you that occurred between she and Mr. Bagley?
Stated that they had been in a physical altercation. She was in a verbal altercation to begin with, and he pulled a bonnet off her head. Stated she had a small rag in her hand, and she kind of threw it at him, which time he grabbed her around the throat and choked her to the point that she blacked out. She was able to get away and ran out of the house. Bagley was not on scene when the police arrived. And we later went and took warrants for aggravated assault.
Did Mr. Bagley reside at that residence at the time?
Yes.
Did Ms. Jackson indicate where Mr. Bagley was when you arrived there?
She stated he might have gone to his mother's house.
Okay. Now, you said that she indicated that that he choked her. Did she lose consciousness at all, or did she say?
She stated that she briefly blacked out.
Okay, I think you were going in and out. What did she say, Detective?
She stated that she briefly blacked out for a moment.
Was anyone else at the residence when this happened, Detective?
Only her children. She stated they didn't see what happened.
Were you able to see any marks or bruises that
I
would
was
indicate
not.
choking?
No.
Did Ms. Jackson provide a written statement at all regarding what happened?
She did.
In her written statement, did it corroborate what she had said to you verbally?
Yes, it did.
And this did happen in Clayton County?
Yes, ma'am.
Thank you. I have no further questions for this witness.
Cross.
Detective Chop, what was the date of the alleged incident of the when Ms. Jackson said that she was
April 17th.
When was the first time you spoke with Ms. Jackson?
April 17th at 6:45 in the morning.
So you went to the location
Yes.
and you said that Mr. Bagley was not at the location?
That's correct. He had left the scene.
And you stated that this occurred immediately after it happened, so there was no delay, correct? You stated
No.
that. Okay. And you've already testified under oath that even though she alleges that she was choked to the point of being unconscious, that when you observed her neck and area, you observed absolutely no injuries whatsoever, correct?
That's correct.
In fact, you did not take out a warrant for Mr. Bagley that day, correct?
No, it was on Monday when I returned to work.
Because you told her that you didn't see any injuries, so there was no proof that she had been strangled or lost consciousness, correct? And that's why you didn't take a warrant. That's what
Well,
you
at
told
that
her.
point in time, that's correct.
Okay. And Ms. Jackson did not require any medical assistance whatsoever, correct?
No,
Okay. And you are a have you handled domestic violence cases in the past in your career?
yes.
Okay. All right. So at some point, I guess Ms. Jackson had reached out to you regarding this issue, regarding made a statement. You said what kind of statement did she make?
She emailed a statement, which was placed in the case that I put in the case file.
Did she make a written statement the day of?
No,
Okay, so the email statement is not a sworn statement, it's just a statement to police, correct?
yes.
And when she made the statement, if the incident happened on April 17th, what time did you receive the statement from her by email?
I'd have to check my email.
Would you say that it was days later?
Yeah, I believe it was that Monday,
Which would be approximately
the
what day?
20th. The 20th.
Okay. And did you speak with her by phone on the 20th or just by email?
By phone. I spoke to her by phone and asked her to email me the because she couldn't meet with me to write a statement.
Okay. Did after this event, this traumatic event, did she ever have contact with Mr. Bagley?
Not aware of that information.
Okay. So she didn't tell you that Mr. Bagley actually came home and everything was fine between them after this alleged choking and strangulation to the point of being unconscious, that Mr. Bagley actually came home and they actually went about their business as if nothing ever happened? Did she tell you that?
No, she didn't make me aware of that. Nope.
Okay. And when was Mr. Bagley actually arrested?
I don't know what date he was picked up. I wasn't the officer that arrested him.
Okay. Do you have an approximate time when he was arrested? After the 17th?
No, I don't.
Okay. After this emailed unsigned statement by Ms. Jackson was sent to you, were you aware she had contact with Mr. Bagley, this person that has been accused of strangulation to the point of unconsciousness? Did she have any contact with this dangerous individual that choked her unconscious between the time of the email, time of his
Your
arrest?
Honor, I'm going to object. Mr. Toles, he'll ask a question and he keeps adding more information into it. Detective Childs has testified once that he didn't know anything about Mr. Jackson or Mr. Bagley coming home or that everything was fine. And so if he's going to ask a question, he needs to ask the question and let Detective Childs answer instead of repeatedly trying to add more information about what he thinks is going on in this case.
Just an interesting phrasing of your questions, Attorney Toles. They sound more like narratives and paragraphs than questions. So I'm going to sustain your objection, ADA Freeman.
All right, I'll stick to my question. Do you know if there was any other contact between the time of the emailed statement between Mr. Jackson, Ms. Jackson and Mr. Bagley?
No,
Okay. Did Ms. Jack, now you would agree that if someone was strangled to the point of and choked, that the person strangling it must have been pretty upset about something, correct?
I'm gonna object that I don't,
Well, let me rephrase it.
Because hold on. It is speculation, counselor. That calls for speculation.
Did she ever tell you what they were arguing about?
That's a
Led up to this.
report. I remember saying it was something very minor. I can't recall exactly what led up to the. Like I said, the main thing was that he snatched the bonnet off her head, and she threw a rag at him, and then he grabbed her and choked her.
Okay, so something very minor is what led up to a choking and strangulation to the
Yeah.
point of being unconscious. Okay. And again, maybe I didn't clarify this, but was any medical personnel? Did you call any 911 to the scene to evaluate someone who had just been strangled unconscious? Did you call an ambulance to make sure that she was okay after such a traumatic
again,
event?
I'm gonna object. It's the questions. I mean, you asked the question and he's asked like 2 questions in this. If he's gonna ask the question about, did you call any medical personnel? That is a question. But I believe Detective Childs has already answered that. He stated that there was no medical attention for the victim.
It's been asked and answered, Attorney Tolles. You did ask that about 7 questions.
Okay. I thought I did. I just didn't know. But I think I said, did he call anybody? I know she didn't get any, but did he personally call someone to assist her? Maybe she refused it. Did you call anybody?
She said she didn't need them.
Okay, she didn't need it. Okay. No witnesses to this particular incident, correct?
Yep.
Okay. Did she tell you about any other issues that she was having with Mr. Bagley?
Other than a recent domestic that I'd worked earlier, about a month prior, I believe.
A recent domestic. Okay, what was that about?
We'd went out, would have to pull the report up. We'd been out about a month earlier. She had alleged that he had struck her.
She alleged that he had struck her?
Yeah.
Okay. And were there any injuries found to her when he allegedly struck her?
No.
So there was no arrest?
No.
Okay. So this particular Ms. Jackson has a history of making allegations against Mr. Bagley that have been previously been unproven, correct?
They do have a history of domestic violence, yes.
That have been unproven?
Yes,
You didn't make any arrests for him striking her, correct?
that's correct.
Okay. Do you know what Ms. Jackson was doing while they were up so early in the morning, or what they were doing?
I don't.
All right. So, but for Ms. Jackson stating that she was choked unconscious, you have nothing to corroborate that in any way, shape, form, or fashion, correct? No marks,
That's correct.
no visible injuries, no hospitalization, nothing, correct?
That's correct.
All right. All right. That's all the questions I have for Detective Childs.
All right. Do you want to do case by case? You want to do it all of it together? Do you want to argue this one first and then do the second case? What is your preference on this ADA framework?
I know Detective Childs has been, I know earlier he was on a call, and so we could go ahead and I guess and finish his case, and then he could, get back to what he was doing, and then I'll have the case with Deputy Arnold, if that's okay.
Okay, that's fine. That's fine. Do you have any other witnesses for the state?
No, Your Honor, not on this.
Okay. Attorney Tolles, do you have any witnesses?
Yes, I do.
All right.
Mr. Bagley, if you could remove, if you feel comfortable doing so, if you could remove your mask, I'd
Let me
like to
swear you
call.
in. Do you swear from the information you have, any testimony you can provide in the matter of the state versus Jermaine Bagley is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Do you understand, sir, that you could say something today that could incriminate you? Do you understand that?
Yes, ma'am.
And you do have the right to remain silent, that anything you say today can be used against your future hearing or trial. I want to make sure you understand that.
Yes, ma'am.
All right, go ahead, sir.
Yes, Mr. Bagley, how do you know Ms. Jackson?
She's the mother of my child. We've been in a relationship for the last going on 5 years. We were actually engaged as well.
Okay. And how long have the two of you been living together?
For 4 years.
Okay. Have you ever been arrested or should I say, have you ever been convicted of a crime involving Ms. Jackson in the past for abusing her or doing anything to her physically?
No.
Okay. And you said you're a father of one of her children as well?
Yes.
And y'all all live in this house, correct?
Yes, sir.
Okay. This house is in Clayton County?
Yes.
Okay. And back on April 17th, were you employed at the time?
Yes.
And where were you employed?
Through a temp service, Pro Logistics.
And what about Ms. Jackson?
She was employed, but both of us were employed, but I had a wreck that I was in, so I was out of work at the time.
Okay. So you were injured at the time during this alleged April 17th assault where you're accused of choking her?
Yes, sir.
And can you tell us about those injuries?
Yeah, I was in a car wreck where I broke my right pelvic bone and like my the bone and socket part of my right leg and my hip on the right side as well.
On April 17th, would you describe any difficulties you had or any pain you might have caused just by moving around?
Yes, I was on medication. I take medication because of my injuries that happened. The wreck happened on March 14th. I've been having to see the doctor back and forth for physical therapy and just all kind of different treatments to try to get myself back walking right.
And on April 17th, maybe I'm just asking more specifically as how you felt on April 17th. Was it in any way painful or difficult for you to move around?
Yes, I was still on crutches.
You're still on crutches, okay. So that would make it more difficult for you to actually choke somebody and strangle somebody?
Yes, sir.
Okay, so we've heard what Detective Childs and Ms. Jackson have allegedly put on the record. It's time for here to hear your side. Can you tell the court, what happened that morning between you and Ms. Jackson that led up to this situation?
No problem. On that morning, I'm not sure if it was even April 17th because I know that when I got arrested, the officer told me that the warrant was actually made on April 10th. I'm not sure about that or not. But what I remember morning, me and Tanisha had been having sex all night, and she woke up late for work. She kept hitting the snooze button. She has to be to work at 7 o'clock. I end up waking up at 6:31 and telling her she had to hurry up and wake up so that she can get ready for work. So she jumped up and she went to go inside of the to get some socks and supposed to where to go to work. And she told me, she was looking for some socks and she couldn't find any socks. So I told her to just grab a pair of mine so she wouldn't be late. She told me that if 3 minutes late for work, that she was gonna get sent home. And when I had asked her to grab my socks, she cursed me out about it. And she said, "Why would I grab your socks so you could be being and complaining at her?" So I said, "Are you serious? Weren't we just having sex all night and things are all good?" And she said, "Yeah, that's the reason why I'm gonna be late because you wanted to mess around all night." And I said, "Well, you the one who actually wanted to have sex or whatever." So she walked inside of the bathroom. When she walked inside the bathroom, she was washing her face. Um, I got up because I had to use the bathroom, and I also had to get up to take her to work because I had to go to the doctor that day. As I was walking in the bathroom behind her, she slammed the door directly on my broke leg, and I pushed the door off of me with my left hand, and I pushed her back off of my leg, and because she was still trying to push the door up against me and telling me to go into the other bathroom, but I couldn't even get out because she was slamming the door on my broke leg. After that,
Was that painful for you?
yes.
Okay, go ahead.
After that, I walked away from the bathroom door to the nightstand that we have on the side of the bed to just to check and see how much time before we had to get back to work. And then when I turned back around and looked at her, she was standing up, and then she dropped on her knees, and then she started faking. It appeared to me like she was faking, like choking or something. And so I walked back up to her and I picked her up and I said, "Are you okay?" And then she said, "What happened?" And she said, "You just choked me, you going to jail." And she ran back and grabbed the phone. When she grabbed her phone, don't play with me, man. I was like, come on now. And then she ran outside with the phone and she called the police. And when she did that, I jumped in the car and just left. Um,
Okay,
whole time, my youngest son was on the bed. My other son was downstairs. Both of them were woke.
So the choking incident is in Europe is a lie. It's not true at all.
Completely alive.
Okay. Um, and did you do anything to stop her from? Did you grab? Did you break her phone or anything, or?
No, I actually had threatened her to break the phone when I said, don't play with me. When she went to go grab the phone from the side of me because it was still on the bed next to my son, she grabbed the phone. I said, don't play with me. I said, don't make me break this phone. And then she just grabbed the phone anyway, and she ran past me downstairs, and she ran outside.
And you allowed her to do that?
Yes,
You did not try to stop her in any way physically from doing that?
no, I didn't.
Okay. The last time you saw Miss Jackson that morning, did you observe any injuries on her whatsoever?
No, I didn't.
Any torn clothing on her?
No,
Scratch, anything?
nothing.
All right. And you saying that after she allegedly said she was choked and strangled, she actually ran out of the house after being choked and strangled. She was able to run.
Yes,
Okay. And make a phone call to the police.
yes, sir.
Okay. All right. So you left. You ended up leaving. You agree this isn't the first time she's leveled false charges against you, correct?
This is the only time that I remember having the police call to my house about anything with us. This is the
Okay.
only time that's ever happened. I don't know what Officer Childs is talking about. Any other domestic disputes that we've ever had. We've never had any other domestic disputes or anything like that before.
Okay. So you don't remember any prior incident where she allegedly
I
said
want to object. He's
struck
already
her?
said that there hadn't been any.
1 second. Go ahead, finish, Counselor.
Whether the incident would involve in the striking in the face. You don't have any recollection of any allegation like that?
No, I've never struck her before. Um, her,
I'm just saying, are you aware of any allegation? Not necessarily that you struck her or didn't strike her, but you don't even remember that even being an allegation that she made?
no,
Okay. All right.
the
Um,
police was called to my house. She left. She went to a motel room before, and her sister called the police to my house while she wasn't at my house. And she thought, I guess she was on the phone with Tanisha, and she thought that I was gonna take my son with me so that when Tanisha left, that she couldn't get my son. So she called the police over to my house, and when the police got there, they was like, why, where's Jermaine and where's Jermaine Jr.?
okay. All right. Let's move along. So after you left the home, um, and Tanisha went out and said she was going to call the police. Did you ever see her again?
Yeah, I saw her when I came back home that same day, probably about an hour and a half later.
Okay. And did she allow you back in the home?
Yes.
Okay.
Took me
Did the
to-
two of you have any other difficulties or anything like that?
No,
Did she inform you that she had accused she had told the police that she had been, she told you that the police that she had been strangled. Did she tell you that?
She told me that she called the police, told me that she didn't write a statement on me, and she told me, yeah, that's all she pretty much told me. She just told me that she didn't write a statement on me. After that, she told me that the police officer, Charles, was contacting her and that he told her that he talked to his boss and that his boss said that he could put an aggravated assault on me. She still didn't write the statement then. We started working with each other because I was released from my doctor to go back to work. And I talked to her about going back to work with her, and she advised me to try to get the job with her. I was supposed to go on second shift, and she was going to stay on first shift. But when I got up there, she pretty much told the people that she didn't want to work with me, and so they ended up firing me just based off of that. It was through a temp service. And so we end up getting, this was actually a week from after the first incident. And after I got fired, I told her that they told me that I was fired because of what she said, and we argued about that. And then she told me that she sent the statement in to Officer Childs on an email. She told me, and she showed it to me and showed me 2 different statements that she had sent to him over email.
Showed it to you.
Yes.
Okay. So she didn't display any fear of you, even an hour and a half after you had come back. There was never any fear of you, someone who had supposedly, had done something so vicious to her. She never prevented you from coming to the house?
No, she didn't. Actually took me to the doctor that I had to go to the doctor.
Okay. So would you describe after this, that morning incident where you all were arguing because she was late for work, that the relationship basically went back to normal?
Yes, pretty much. Besides that, we got into it about me getting fired about my job, and then that's when she wrote the statement. But yeah, we were still actively having sex. We were going out to, and we had actually went to the 12 motel, probably like the week before I got locked up. We had a get together that we had at the 12 with that's us and the kids.
Okay. All right. Okay. And so, but eventually you were arrested for this. Is that correct?
I was arrested May 5th, and I had just picked my kids up, and I was on my way to go pick her up from work. I was still taking her back and forth to work because I was still having to go see the doctor.
Where exactly were you arrested? I mean, where were you when you were arrested?
I had just pulled back up to my house.
Were there police at your house?
I didn't see them. Once I walked in the door, I had the kids. The kids were outside. The car was still crunk. I had like 2 other people with me, and the fugitive squad came in right behind the second person that was coming in my house.
So you arrested in front of your kids?
Yes.
Okay. All right. That's all I have, Judge.
Cross?
Thank you, Your Honor. Good afternoon, Mr. Bagley. I just have a few questions. I know you said that you and Ms. Jackson had not had any previous, I guess, disputes like this. Now, but you do have a previous conviction for an aggravated assault, right?
Judge. Objection. That's not relevant to, that's improper evidence from some incident that has no relevance to this case.
Attorney Freeman?
Your Honor, I believe it is relevant. He stated that that Ms. Jackson, that he had never had any disputes with her. My question was going to be if she was the victim in that aggravated assault.
The DA knows she's not, and that's not.
Well, I don't know if she is or isn't.
Well, hold on. So if he said he's got no previous arrests, hold on, did he say he has no previous arrest?
Involving Ms. Jackson.
Okay, so if that's what he says, you're cross-examining him on that point?
Yes, Your Honor, because I don't know who was the victim in this case.
Counselor, I'm gonna let her cross-examine him on that point.
Okay.
not on his previous history, but on that point. So I'm overruling your objection to a point where she can clarify something he's already testified to about this victim.
Thank you, Your Honor.
No, I have not had any domestic disputes with Tanisha Jackson.
Well, I guess my question then is so I'm clear, because I don't have any prior police reports. Was Miss Jackson the victim in your previous aggravated assault?
I'm sorry, I'm missing the question.
Okay, I'll break it down some. You have a previous aggravated assault conviction, is that right?
No,
So you didn't have an aggravated assault out of Fayette County?
no,
What about out of Fulton County?
no, I was not convicted of anything in Fulton County either.
Well, I think the question, Judge, and I think we're kind of getting off base here, is was there, have you ever been, have you ever been arrested for the aggravated assault that she's talking about? Did it involve Ms. Jackson? Whether it was a conviction or not, was the arrest or anything have anything to do with Ms. Jackson?
Well, that was my question, but he indicated that he did not have a previous aggravated assault. And so I'm trying to make sure that what I'm looking at is correct. And then my next question certainly was, well, who, if was
Hold on. You're entitled to a thorough and sifting cross-examination, but you can only cross-examine in the issue that his attorney has brought up. So you can't go outside the scope of the direct.
No,
Sounds like that.
and I'm not trying to, what I wanted to ask him if she was the victim of these aggravated assaults, but what threw me is when he indicated that he didn't have an aggravated assault.
Don't talk, Ms. Bagley. Don't talk. Let your attorney talk for you.
But you know, I can certainly move on, but that's where I was, what threw me. And I was just trying to get some clarification.
To clarify. All right, we're gonna move on that way.
Yeah, I can move on. That is
treading. There's no treading on this area
right.
that you're not entitled to tread on.
Right, and I can move on. And that's actually all I have, Your Honor.
Do you have anything else, Attorney Tolles, with this client?
I don't have any questions outside her cross-examination. I don't think she didn't even talk about the case. So I don't have any questions, I guess, because we really didn't get into anything really. So no, I don't have any questions.
Okay, all right. Any other witnesses? Attorney Tolles?
Oh, sorry. No further witnesses, Judge, because I don't think there were any.
Argument?
State ways opening.
Okay.
Judge, when it comes to, probable cause, I think we need to go back. Detective Childs, first came out and talked to Ms. Jackson. Now he's a trained law enforcement officer. He's not gonna, in the moment of things, he's making judgments. And when somebody tells him that they've been strangled to the point of unconsciousness as a detective, your actions speak louder sometimes than the words that the victim speaks. And the fact is that when he evaluated this witness at the time that it was made, he made a decision not to arrest or even take out a warrant on Mr. Bagley at all because he saw no injuries. He clearly did not see someone that had been in such a serious matter that they even need any hospitalization, didn't even call for an ambulance. Jackson did not call for an ambulance. And also nothing was ever provided to the officer that, what facts would have led up to an officer that would have made Mr. Bagley so upset that he would do that, especially in light of the fact that he was suffering from a very serious injury from a car accident that would have prevented him from, taking such a serious action against Ms. Jackson. So beyond that, with Mr. Bagley coming back and an hour later after them basically going on, I would ask this court to consider that, when you consider the allegation that was made, a very serious allegation that was made, you don't just get choked out unconscious and then an hour and a half later, oh yeah, y'all are just going to go to lunch and the 12 hotel and go about your business, if that was actually true. So this Ms. Jackson has a history of contacting the police and kind of being, I would say, causing drama and things of that nature. There's just no evidence, Judge. There's no probable cause evidence that no physical evidence, no eyewitnesses, nothing. And Mr. Bagley did not have to testify here today. The only evidence that you have here before today, Judge, is hearsay evidence from Detective Childs about Ms. Jackson, but even his observations did not support an arrest for aggravated battery. It was only after some supervisor got involved and they heard, but they didn't see what Detective Childs saw. And Detective Childs saw, he didn't see any evidence. It was only after the supervisor got involved that all of a sudden Detective Childs all of a sudden has to make an arrest. So at this point in time, Judge, probable cause has not been established against Mr. Bagley. This is a very, very serious charge, Judge. And if there was any evidence to support it, Mr. Detective Childs would have arrested him or took out a warrant that day. And Ms. Jackson would have gotten a TPO. She would have never been allowed a man to do who had done that to her to just go back and as if nothing had happened. Judge, she fabricated that, and that's why she just sent the email. That's why there was never any written or anything as far as anything signed, because she was probably more concerned now that she had made this allegation and now she could go to trouble. She get in trouble for telling lies to the police. So now she's just sending emails. But meanwhile, while she's sending emails, my client's reading the same email and in the house with her at the same email. It's just a bizarre case, Judge. There's no evidence, and I would just ask that Mr. Bagley is a father. He's doing things like that. That to give him the benefit of the doubt that he's testified. Ms. Jackson could have come in here and testified herself. She, the state's alleged, they can bring in hearsay, but they don't have to bring in here. They can actually bring the witnesses that, to testify under oath, if they're actual victims, they can do that. They don't have to use hearsay, but that's what they've chosen to do. And with Mr. Bagley stating that there's just nothing going on here, Judge. So I'm going to ask, I'm imploring the court to please not bind a aggravated assault strangulation with no injuries and no medical attention, and the police didn't even make an arrest that day. I'm asking the court, do not put that on Mr. Bagley. And so I'm asking the court to dismiss the aggravated assault.
All right.
Your Honor, thank you, Your Honor. And we are asking that the aggravated assault be bound over. And as Mr. Toles knows that certainly at this stage, rarely does the state bring the actual victim to testify, because we certainly don't want to have the victim have to relive or what may have happened over and over again when it's not necessary. Detective Childs, who is an experienced detective, we heard he's been with CCPD for quite some time. He didn't take out a warrant at that time. He waited until he got a statement from Ms. Jackson, which corroborated what she had verbally told him. We've had, this is not the first aggravated assault case where the officer did not see any bruising or injury to the neck area. That certainly is not indicative that a strangulation did not take place. And so when Detective Childs arrived there, he got a statement from Ms. Jackson verbally, where she indicated that Mr. Bagley choked her to where she blacked out momentarily. She subsequently sent in a statement and he took out a warrant. The fact that there were no injuries to her neck, certainly the state believes that is not indicative that the incident did not occur. And so we are asking that the aggravated assault be bound over to Superior Court.
So I don't know that I've ever had an aggravated assault where there were no bruising, no marks, no nothing, no redness, no nothing on the neck. I don't know that I've ever seen one. And had I seen one with no evidence of anything or any corroboration from a witness, the children or something, I would have needed something other than one person's word against another person's word, because that's just too easy to have everyone locked up. If you're mad at someone and you say they strangled me until I blacked out, then what kind of, I don't find probable cause for this. I don't find probable cause for this. All right.
All right, Your Honor, and may Detective.
Hold on 1 second.
We got a second case.
1 second, 1 second.
I know, Mr. Bagley, got a drug case you got to deal with.
Mhm.
Cheryl, can I
Yes,
ask you a quick question?
sure.
Does the do the bond amounts that for the other charges, is that something that still stands that?
No, we can certainly discuss it. Let me see. Your Honor, well, Charles, I think you can be excused because we're finished with your case. Thank you. No, we can, let me see, what did I text you? Because I don't want to say it over the screen. Let me see.
I received your text, yeah.
Did you see it, what I indicated?
Yes, you. That's what I'm asking you, of the amounts that are remaining. Is that something that can be done? If so, I'd like to.
Yeah, what I text, that's still.
Yes. Okay, well then, if y'all have another hearing, I'd like to be put in a breakout room to discuss that with Mr. Bagley at some point in time to see if.
Okay, I don't have any, I don't have an objection. We can ask the judge if she could do that. If I could have Arnold just hold tight for a minute, and I know I had Kelly on, who's on Springer. Let me find out where Kelly went. Chris, do you have a breakout room already? Are you already assigned to a breakout room?
No, I haven't.
Okay.
I'd have to ask the court to do that, and.
Okay.
Okay, so what's going on here?
Mr. Toles wanted to know if he could be put in a breakout room or have an opportunity to speak to Mr. Bagley about a bond. We had been communicating before, and of course, the aggravated assault was the more serious charge, and he wanted to talk to Mr. Bagley about bond recommendations on the drug charges.
All right, so what I'm gonna do, the jail is in breakout room 3. I'm gonna move the jail to breakout room 4. Mr. Attorney Toles, I'm gonna move you to breakout room 4.
Thank you, Judge.
Talk to your client, just wanna talk to your client.
Yeah, I want to talk to him about this before we come back.
Okay.
And Arnold, just stand by if you can.
Yes, ma'am.
Just stand by. Thank you.
Thank you.
And Judge, I am getting, Kelly was logged in.
I saw him.
Right, and so I'm trying to get him back also.
Okay. All right. I have not eaten. I've been chewing. So I'm gonna take about a 10-15 minute break so I can just grab something to eat, okay?
Okay, all right.
Come on,
Arnold,
I'm gonna go to YouTube.
okay, we're gonna take